All right. Hello, everyone. This is Juan Allan from First Allan, and this time we are pouring back from Italy. This is the CISO webinar, Chapter 4. Today we have great presence of Paul McCulloch. He's the managing member of the Cybercheck One company. Hello, Paul. How are you doing?
Doing well. How are you doing today?
Everything's doing fine. Just in Italy now, so less different time zone with the US and Latin America than before.
Yeah, it's good to talk to you. I really appreciate the opportunity. These are a lot of topics that are very near and dear to my heart, and I love talking about them. So if your listeners really do enjoy talking about this, then I'm always willing to share information.
That's amazing. Yeah, it's our pleasure to have you. Someone with a lot of knowledge on legal topics and also
Mhm.
cybersecurity. So it's amazing.
Thank you. And before we start, actually, so I am a New York licensed attorney, and I do deal with cybersecurity, technology, privacy, emerging technology issues. But what we discuss is not legal advice. I just have to say that disclaimer. I'm not your lawyer. This is not legal advice. This is a conversation amongst two experts in the field.
Well, thank you very much for clarifying that. All right, so now we can start now with a couple of questions. The first question is kind of a more broad. I would ask you, what is your opinion in today's cybersecurity regulations from a domestic point of view in the United States and also from a global perspective?
That's a very broad question. So cybersecurity in the United States. Okay. So I think that the main thing we have to address is there's been a change in the administration. There's been a lot of changes in different approaches to, privacy, cybersecurity, and what have you. Um, Cybersecurity was on a trajectory at the end of 2024 that has since been modified. So in terms of looking at it from the pre um, current administration, I'd say that the cybersecurity requirements were very well established in the United States at a federal level. You had NIST frameworks. You had things like the Federal Financial Institutions Examinations Council cybersecurity framework based off of NIST, which was for financial institutions. But even that is a great example. That is being sunset in August. So it'll no longer be used, but that's because there are also additional and various alternative cybersecurity frameworks and methodologies. And that actually goes to the next point, which is, with the emerging legislation in artificial intelligence and quantum and all the kind of risks that regulators are seeing come down the pike, all that is kind of boiling down to different frameworks that are being used in the various jurisdictions. So in terms of kind of where the US is in terms of cybersecurity, we've got the pre-existing players, the Computer Fraud and Abuse Act, which criminalizes hacking, the Cybersecurity Information Sharing Act, which is more a way for the private sector to share intelligence with the public sector. You've got agency requirements like the SEC cybersecurity disclosure rules that require SEC covered companies to disclose cyber incidents. And then you've got, the rules for just, the agencies themselves at the federal level, which are, like EO 14028, which strengthens the software security standards for the federal agencies. Now, you've got all that at the federal level. Then you've got all the industry standards. So you've got the energy industry has their own cybersecurity standards that those are continuing to develop at a pretty good pace. And you've got the state standards where each state is developing its own take on cybersecurity. In the United States, there's federal preemption, but if a state comes up with its own requirement, it usually is more controlling or addresses things that the federal law doesn't necessarily address. And then in the EU, for cybersecurity, we've got, and I'm just addressing these two big players. The EU, you've got GDPR, which I'm sure your listeners are familiar with, General Data Protection Regulation, which covers the personal data. You've got the NIS2, which has the cybersecurity requirements for essential services. And then you have DORA, which is, I guess the most relatively recent, which is cybersecurity in financial services. You have all these frameworks being developed that are usually either at a sort of federal, like national level, state level, or industry level. And so anytime any of those players decides to change their mind on the course that they want to take, it ruffles the feathers of everyone else. So that's pretty evident in, for example, the artificial intelligence executive orders that existed under the Biden administration that were, seeking to control a lot of the risks presented by artificial intelligence, whereas the current administration, the Trump administration, is a lot more innovation friendly, shall we say, and kind of peels away some of those restrictions. Um, does that answer your question?
Yes, sir. I appreciate that. Let me ask you some other question from a consumer's perspective. For example, when I'm in Europe, right now I am from my computer, I open a tab, right? And I see, usually some displays about, if I agree to comply, that like the privacy, of the website, right? This is something that, I see happening, a lot of Europe, like when you open, for example, some websites, but, it's something that I don't see, in Latin America, I don't see in Asia, right? Like, for example, like I open, I don't know, kiwi.com, some X website, unless that they ask me if I complied, to give access to my personal data. Um, why is that? And also, do you think that consumers are more secure about, personal data in the US, Europe, than in Asia and Latin America, or how that plays?
Ooh, all right. Um, those are multiple steps to that question. So the second part is how the consumers perceive of their privacy in various jurisdictions. The first one is kind of when you approach a privacy policy in the EU, it asks, do you agree to our privacy policy, to cookies, to all these? Okay, so I think that the GDPR kind of set the standard for much of the world in understanding what are the privacy rights that to which a consumer can be entitled. The right to access, deletion, correction, limitation on data. Only collect the data that you need. There's a whole gamut of protections. In the United States, the California I get CCPA, which was first in California. It takes all the rights of GDPR and with the addendum CPRA, kind of expands the rights of consumers in California, so they have a lot of the same rights that exist in GDPR. CCPA didn't initially have all those rights, and then CPRA came into effect and expanded those rights and made a few other changes, increased fines, and what have you. So, if you're in California and you're in Europe, conceivably there are similar obligations. Your privacy policy has to have disclose the cookies. You have to consent to certain cookies, and there are requirements for consent management, consent capture, and so I would say those two jurisdictions are kind of the more the ones that are the standard setting. Now, if you look at the United States in general, as of today, I believe there are 20 state privacy laws, and each one has different standards. Not all of them have all of the protections that California affords, but all of them have one or a few. Um, and GDPR, it applies obviously to European companies and anyone doing a European data transfer. California only applies in California unless you have over a certain number of people doing business there and a certain volume of transactions. I think only Texas and Nebraska are the ones that apply to everyone, no matter what, if you take the data from their users. Um, so, from what I mean by that is a consumer really doesn't know what they're going to get based if everything's based off of jurisdiction. A smart company would have the most conservative standards because it seems that states are progressing towards reaching kind of a GDPR like level of data protection and privacy. And obviously the Brazilian data protection law and the Australian data protection laws, they're also very, very far along, very, very mature. And I see that countries more and more are kind of advancing that way. Now, it does kind of speak to what a country does, the appetite and the expectations of the consumers. So I would say that Europeans are and the consumers in Europe have more of an expectation of privacy, more of an expectation that their rights would be protected. In the United States, under the prior administration, maybe privacy rights were more protected than they are now. Or there are other vectors. For example, if in the current administration, the Trump administration, they do base a lot of their kind of activities on Project 2025. And some of the themes in Project 2025 and the current administration has reflected is enabling a private right of action. So there's some very high level federal protections that touch upon privacy. For instance, CAN spam. The Federal Trade Commission, if you get an email and you unsubscribe, I think it's 15 days. If after 15 days that person still sends you an email, it's I believe, a $450 fine for the email. But it's up to the Federal Trade Commission to bring that case against you. If the private right of action is enabled, that means any individual can sue another company for a private right of action. The US is a little bit more litigious than most jurisdictions, so you'll find a lot more class actions popping up for people who are like, wait a second, I do have that right. The government's not taking care of it. I now have the right to bring a case. I'm going to sue. So consumers in Europe, I say, have that expectation of privacy a little bit more standard. Consumers in the United States, as long as you're not adversely impacting my rights in a very obvious way. People sell their data and there's abuse of data everywhere. But if it comes to the point where I'm able to sue you and get money for the misuse of my data, that's when you're going to see people start following a little bit more of the privacy laws and privacy protections being expanded. That's my belief.
So it would be, certain to say that the consumers are more protected in the US, in California and Europe than, for example, some other states, correct?
Uh, I have to speak to my specialty. I'm familiar with the laws of US, UK, Singapore, Hong Kong, Abu Dhabi, and a few other countries.
Okay.
In terms of speaking to privacy protections in countries that aren't those, I know that India has a very, very strong privacy law. I can't speak to the details or the enforcement metrics, but there are other countries that don't have privacy laws on the books. And so those are, they are subjected, the participants in those countries are still subjected to privacy requirements, usually by their industry or self-regulating organizations, or privacy requirements that are imputed upon them by third parties. So for example, if I'm a medical facility or a medical service provider and I touch electronic protected health information in the United States, and I'm going to share it with the Philippines, I need to have a business associate agreement that discusses how I will treat that data and how that data is supposed to be protected, as well as a whole bunch of other issues. Actually, I'm not even going to say that because I don't know if the export of data is there's a lot of legislation developing that is prohibiting the export of certain data unless absolutely necessary. So that's another thing to take into consideration as an emerging trend. So yeah.
Now, thank you for your insight. If you switch a little bit, scope from consumer to companies, in your opinion, what are, kind of the main challenges that, multinationals or companies, are facing today, kind of in a worldwide, scope, also from a cybersecurity perspective and privacy laws worldwide?
Okay. So it's a good question. There's a lot of problems that multinational companies are facing across different jurisdictions. But if you look just from a corporate formation or a corporate management vantage point, it's you have enough people in one jurisdiction to justify what's being done. Do you know what kind of incentives, tax incentives, grants are you getting from like aid from different governments? And there's a whole host. So we're focusing just on privacy and cybersecurity here. And so we'll talk about kind of the biggest one, which is privacy and data transfer. First is the data that if I'm a company in multiple jurisdictions and I'm transferring data from one jurisdiction to another, first of all, if one jurisdiction has stronger consent management requirements and more protections, am I making sure that those are protected in this other jurisdiction that I'm in? And that's kind of something that was addressed by GDPR by having, binding corporate rules or, adequacy requirements like, hey, you might not be a European country that has GDPR, but in your country, I believe Korea is one, you have similar protections. So, you can go launch there. And we believe companies that launch there and that come here from there and the data transfers in between the two have that certain minimum level of protection, right? So, there's in terms of data transfer, yes, it's what are the protections to the data, and the kind of relationships of both countries' privacy laws, and amongst one another. The other is just kind of if you go into the more technical aspect, I believe that so things like encryption. Encryption was considered a munition until I believe 1974. So essentially, you were like an arms dealer if you sent encryption to an unauthorized jurisdiction. I think since then, the ITAR, which is International Traffic in Arms Regulations, does have certain standards for encryption. So, for example, if you're using a certain encryption standard, you may be restricted from the United States sending it to someplace like Russia or China. And if you import a certain encryption standard into those jurisdictions, they could consider it an act of espionage even. So you have to really watch out, like not just the data itself, but how it's encrypted and then, stored, accessed, protected. And then there's, document retention requirements different for every jurisdiction and document destruction requirements different for every jurisdiction. So entire data management life cycle basically has the different requirements across jurisdictions. You need to make sure that you harmonize amongst all of them. So you find the most controlling standard, most conservative standard, which GDPR if you have offices in Europe, and then obviously you're going to want to store as much data within those jurisdictions as possible. You don't want to transfer too much data everywhere else. And then obviously de-identify, anonymize, pseudonymize, like lower your risk as much as possible. And I believe a lot of insurance companies and even reinsurance companies have created some pretty interesting standards to help companies understand, what are the risks and how to mitigate the risks in their business, and so that they can get insurance. I mean, if you really want to understand, who's identifying the risks in cybersecurity, look at the insurance companies that are trying to sell you cybersecurity insurance, and then look at what they, explicitly don't cover, and you'll see where the biggest risks are for companies. So, in terms of the challenges, kind of for cyber and privacy worldwide, it's just data lifecycle management, data management, and then dealing with the incident response times. I mean, I was in a role where I had to be on the phone with a regulator within 1 hour in one jurisdiction if there was a potential breach, or 36 hours in another jurisdiction, and the content of the regulatory reporting had to be very different. So, managing all that is it's a lot of fun, actually.
Let me ask you one final question. Quite simple. Is data important? And if yes, why?
Come again, is what important?
Data, like any data you find in the internet,
Oh,
information. What?
I mean, data is an incredibly valuable asset. There's a few companies popping up right now that can actually take your entire data sets and use their metrics to tell you what the value is of that data and enable you to get a currency loan against that data of its value. So data has value as straight money. Data has a value as market access. Data has a value to be able to do advertising and manipulation. I mean, there's many governments that are trying to get their hands on as much data as possible, especially with accelerated processing capabilities from AI and the accelerated quantum processing capabilities. You'd be able to ask an AI, great, I want to find out how I can get this group of people to and to do what I want them to do. And the AI can say, great, here are the touch points. I mean, you look at companies like, Palantir, they do exceptional work with data and, making inferences from that data. So is data valuable? Yes, I think it is one of the most valuable things out there. Data is information. It's also one of the riskiest things, and it's becoming more and more risky, which is why you can have the data, but pseudonymize it, protect it. Just make sure in your technology contracts, which I look over hours and hours every day, that you're properly identifying liabilities and allocating them to the respective parties, which are not you. So yes, data is incredibly valuable and it's only getting more so.
Thank you very much. Any final comments you want to say about any topic or anything?
Um, Frankly, in the fields of technology, privacy, cybersecurity, where I work in every day, the biggest risks are human risks and kind of vendor management. But those could also be opportunities. So, maybe not human risks, but vendor management. If you know how to read a technology contract, you can make the liability belong to your vendor. You can make sure your vendor has certain licenses and sub-licenses them to you. Um, and yeah, I think right now it's technology law is the game of identifying the risk and offloading it to your counterparty, especially as different states, federal entities, and industry bodies are continuing to change the laws very, very, very rapidly. So if you can't follow all the laws or keep track of them, rather, if you can't keep track of all the laws, regulations, then I think offload the liability of that onto third parties, and you should be in a good spot, especially since things are only moving faster.
Well, this was Paul McCulloch, the managing member of the Cybercheck One for FAM. Paul, thank you very much for your time. It was really interesting and amazing knowledge that you shared with us today.
Sure. You're welcome, and thanks for having me.
Peace.